Live from the drama free true crime destination. No distractions, no detours, just the cases, the clarity, and the conviction you deserve. This is the main event. And welcome on a late Friday afternoon, early Friday evening, wherever you are in this great country of ours. Welcome, one and all, to the main event inside the drama-free true crime destination. I'm Ernest Bethea, the last outlaw, and today I have what I like to call a not so perfect 10 lineup. 10 stories for your true crime fix. So I'm not going to waste any time. Let's go ahead and get started with our first case on the docket. And we're opening things up where the prosecutors are not seeking the death penalty against a mother who poisoned Thanksgiving dinner. Hmm. Here's what's going down. North Carolina, a woman accused of intentionally poisoning her own family with Thanksgiving dinner will not face a potential death sentence if convicted. The prosecutors announced it this week. Gudrun Casper Leinenkugel, if I'm pronouncing it right, if not, hold it against my pronunciation. She's facing 2 counts of first degree murder and 2 counts of attempted first degree murder after allegedly intentionally poisoning her 2 daughters and one of their boyfriends. She's also charged with murdering a man in 2007. On Thursday, prosecutors filed paperwork declaring they would not seek the death penalty in the event of a conviction in the case. When investigators initially announced the charges, they said that they were continuing to investigate additional deaths that could be tied to the defendant. However, no new charges have been filed. The prosecutors say Casper Leinenkugel served the victims wine at dinner that had been laced with aceno, acetonitrile, a substance converted to cyanide in the human body. A previously scheduled probable cause hearing was canceled after prosecutors secured an indictment against the defendant. She remains behind bars without bond. All right, I'm going to try to pull this breakdown up. Let's see what we got here. The defendant is a 52-year-old Gudrun Linda Jean Casper Leinenkugel of Henderson, North Carolina, accused of poisoning family members during a Thanksgiving gathering on November 30th of 2025. The wine was allegedly laced with acetonitrile, a chemical that metabolizes into cyanide. Her 32-year-old daughter, Leila Jean Livis, died the next day. 2 other guests survived. She is also suspected in the 2007 poisoning death of Michael Schmidt. That's the person that they didn't make mention in the article. As I've mentioned, she's charged with 2 counts of first degree murder, 2 counts of attempted first degree murder, multiple counts of distributing a prohibited or harmful substance. All charges stem from both the 2025 Thanksgiving incident and the alleged 2007 poisoning. The prosecutors deciding not to pursue the death penalty during a Rule 24 hearing on February 26th of 2026. Prosecutors formally announced they would not seek the death penalty. The case will proceed as a non-capital trial, though first-degree murder still carries life imprisonment. Prosecutors appear focused on securing convictions based on the evidence rather than pursuing execution. The defense's posture, their attorneys saying that they have not yet seen evidence that proves guilt, describing what they have heard as theories. The defendant has pleaded not guilty and intends to mount a vigorous defense. reaction from family and community. Travis Peterson, the father of the deceased daughter Leela, expressed shock and said he believes the defendant deserves to die, highlighting the emotional weight of the case. The case has drawn intense public interest due to the alleged method, the family dynamics, and the long term pattern investigators suspect. Authorities have initially suggested they were investigating additional deaths, potentially linked to the defendant, even though no new charges have been filed. The chemical involved, acetonitrile, is an industrial solvent that becomes cyanide in the human body, causing delayed toxic effects consistent with the timeline of her daughter's death. Guys, of all the things one can do, you still have to wonder what the motive behind it all is. Why would a mother intentionally try to kill her daughter or her boyfriend or whatever it is, or and another pair? It sounds awfully strange to me. Awfully strange. All right, next up, Laken Riley's father is filing a lawsuit against the Georgia University system, accusing them of negligence. From stemming from the death of his daughter. Let's go to Atlanta right now. The father, okay, give me 1 second. The father of Laken Riley, who was killed on the campus of the University of Georgia by a Venezuelan man who lived nearby, is accusing the state university system of negligence that he says led to his daughter's death. Jason Riley filed a wrongful death lawsuit against the Board of Regents of the University System of Georgia, as well as several property management companies. His daughter, a 22-year-old nursing student, was killed in February 2024, and Jose Ibarra was convicted of murder and other charges in her death. Just an hour before Riley was killed, Ibarra had looked into the window of the University of Georgia graduate students' on-campus apartment, and tried to open the front door before fleeing into a wooded area. The lawsuit alleges that the Board of Regents failed in its duty to provide a reasonably safe premises and failed to notify students and guests on campus of the threat posed by Ibarra that morning. Soon thereafter, with no knowledge of the potential assailant and no reason to suspect any danger, nursing student Laken Riley went for her routine morning run near the intramural fields on the UGA campus, according to the lawsuit. A Board of Regents spokesperson said the board does not comment on pending litigation. The lawsuit filed Monday in Gwinnett County State Court also says the Board of Regents failed to follow its own policies and procedures on screening employees, which resulted in Ibarra's brother, who was also in the country illegally, being employed on campus. And it says the board failed to monitor criminal activity on campus. Prosecutors said Ibarra encountered Riley while she was running on the University of Georgia campus in Athens on February 22nd, 2024, and killed her during a struggle. Riley was a student at Augusta University College of Nursing, which also has a campus in Athens about 70 miles east of Atlanta. 28-year-old Ibarra had entered the United States illegally in 2022 and was allowed to stay while he pursued his immigration case. Riley's killing in 2024 heightened tensions in the national debate over immigration. The lawsuit also alleges negligence on the part of the property management for the apartment complex where Ibarra lived with other people, including two of his brothers. The property manager failed in its duty to properly screen prospective tenants, which allowed Ibarra to live there regardless of the fact that he was in the country illegally and had a criminal history. Had the property manager not permitted Ibarra to live in the apartments in close proximity to the citizens of Athens and the students of the University of Georgia, Ibarra would not have had the opportunity to assault and murder Ms. Riley in February 2024. Riley's father is asking for a jury trial, and he is seeking compensatory and punitive damages as well as reimbursement of legal costs. Let me give this some structure. Core facts. Laken Riley, a 22-year-old nursing student, was killed while running on the University of Georgia campus on February 22nd, 2024. Her convicted killer, Jose Ibarra, a Venezuelan national who entered the U.S. illegally in 2022, was later sentenced to life without parole. Riley's father, Jason Riley, has now filed a wrongful death lawsuit against the Board of Regents of the University System of Georgia and several property management companies. Here's all the allegations in that lawsuit. Again, the lawsuit claims the university system failed to provide a reasonably safe campus environment despite clear warning signs. They failed to notify students after Ibarra was reported as a peeping Tom just over an hour before the murder. They failed to monitor criminal activity on or near campus. And they failed to properly screen employees, resulting in Ibarra's brother, who's also undocumented, being hired on campus using a fraudulent green card. They were allowed unsafe housing conditions. But let's see. He was allowed unsafe housing conditions, accusing apartment managers of not screening tenants with violent histories or undocumented status. Here's that timeline of events. Around 7:57 a.m., a student reports Ibarra peeping through her window and attempting to open her door. No campus alert is issued, according to this lawsuit. Around 9:10 a.m., Riley's phone triggers an SOS call. A struggle is heard. Later that afternoon, Riley's body is found in a wooded area off a running trail. December 2024, Ibarra is convicted of murder. February 2026, Jason Riley files a wrongful death lawsuit. Jason Riley is seeking compensation for the full value of his daughter's life, including lost future earnings and companionship. Punitive damages against the Board of Regents and property managers for alleged negligent acts and omissions. Punitive damages, I mentioned, against the Board of Regents and property managers for alleged negligent acts and omissions. And accountability for systemic failures he argues directly enabled the attack. The response from the Board of Regents, first from the Board of Regents, they've declined the comments, citing pending litigation. The University of Georgia also issued no comment out of respect for Laken and her family. Property managers named in the suit have not publicly responded. And for broader context and impact, Riley's killing intensified national debate over campus security, immigration enforcement, and university liability. This lawsuit will underscore how much universities handle real-time threats, whether campus police and administrators acted with due diligence. The responsibilities of property managers, easy housing individuals, and criminal histories, and the intersection of immigration policy and public safety. I got a feeling while Jason Riley is ready to sue both the Board of Regents and the Georgia University system. Both of those parties will be playing will be working hard to cover their own behinds before this thing is all over with. All right. There we go. All right. Next up, an Amish mother stood trial this week on murder charges of her son. And of course, this is a two-piece because I have a updated article coming with that. All right, we are in New Philadelphia, Ohio for this. An Amish mother accused of drowning her young son in an Ohio lake faces trial this week without a jury. I'll talk about that in a little bit. Ruth Miller has pleaded not guilty by reason of insanity to multiple charges, including aggravated murder and felonious assault. Rather than face a jury, she has opted for a bench trial, which means the judge alone will decide her fate. Now, I'm stopping right here to say, just long enough to say, I know she's Amish, but even with this decision, she's literally rolling the dice. Prosecutors say Miller drowned her 4-year-old son before attempting to drive a golf cart into the water with her 3 teenage children on board. Body camera videos recorded by responding officers show Miller telling them, I gave my son to God, and that her husband was at the bottom of the lake, had been swallowed by a fish. Miller's attorneys had his hearing. Let's see, Miller's attorneys have argued that she was suffering from severe mental illness and said at a previous hearing that Miller has been receiving counseling and medication while behind bars. The court expected the trial to last only one day. Well, ladies and gentlemen, I am here to tell you it did last only one day. And here is the update from that trial. Amish mother who was accused of murdering her 4-year-old son and attempted to harm her older children, who was found to be insane at the time of the slayings. Ruth Miller is not guilty by reason of insanity, Judge Michael Ernest said in court on Tuesday. I think that's the only conclusion that can be reached. Miller faced 7 charges in connection with the deadly incident at Atwood Lake on August 23rd, 2025. Police body cameras showed this from the scene showed her talking to officers and telling them that both her young son and her husband were at the bottom of the lake, taken, and had been swallowed by a fish. Police said that after drowning her 4-year-old, Miller then tried to hurt her 3 teenage children by driving a golf cart into the water with them on board. Miller had pleaded not guilty by reason of insanity and opted for a bench trial. Miller had pleaded not guilty by reason of insanity and opted for a bench trial, which means Judge Ernest was responsible for deciding her fate rather than a jury, with no opening statements, witnesses called, or closing arguments. The judge relied on the evidence submitted to the court through reports authored by forensic psychologists, psychiatrists, witness statements, and police body worn camera. Witness statements describe Miller as having an acute mental health crisis in the days and weeks leading up to August 23rd. Witness statements describe Miller as having an acute mental health crisis in the days and weeks leading up to August 23rd, which included grandiose and delusional thinking and a belief that God had asked her to be swallowed by a fish. 3 mental health professionals who examined Miller agreed that she suffered from severe mental disease, and at the time of the incident, when Miller was found not guilty by reason of insanity, she was not released from custody. She will remain in the county jail for the next 10 days, pending a hearing to determine her fate. That hearing will be held next week, Friday, March 13th. Friday the 13th. Here's the overview as of right now. 40-year-old Amish mom named Ruth Miller from Holmes County, Ohio, charged in the August 23rd, 2025 drowning death of her 4-year-old son, Vincent Miller, at Atwood Lake. She was also linked to the death of her husband, who was found in the same lake. The case involved allegations that she acted under a spiritual delusion, believing God had distracted the others. She was originally. Oh wait! I'm skipping over something. She's also linked to the death of her husband, who was found in the same lake. The case involved allegations that she acted under a severe spiritual delusion, believing God had instructed her actions. On the charges, she was indicted on 7 counts: aggravated murder, attempted murder, murder in the first degree, child endangerment, and domestic violence. Those charges stem from her throwing her 4-year-old son into the lake and driving a golf cart into the lake with her 3 teenage children aboard. Statements indicating she believed God told her to give him to God or that they could walk on water. The bench trial was unusually streamlined. No witnesses were called. No opening statements or closing arguments were made. All right. Because I know I'm missing. Jeez. Hang on, guys. Yeah, the judge relied on mental health evaluations, police body camera footage, and witness statements. As you heard, the verdict was not guilty by reason of insanity. On March 3rd, 2026, Judge Michael Ernest ruled Miller not guilty by reason of insanity on all 7 counts. The key findings was that she was experiencing a severe psychotic episode, and she exhibited grandiose and delusional thinking, including believing wanted her to be swallowed by a fish. Multiple witnesses and mental health professionals corroborated her deteriorating mental state. What happens next? Ruth Miller was not released. She remains in custody pending a March 13 hearing to determine her placement in a secure mental health facility. The court will be will decide the level of treatment and security required. Let's see, remains in custody during pending a March 13th hearing to determine her placement in a secure mental health facility. The court will decide the level of treatment and security required. So, ladies and gentlemen, it's kind of over, but not really. They still have to decide whether she is going to not whether she's going or not, but to which one, which mental facility will she be housed in, and for how long. So when I get that information, count on it being brought to you right here. Next up, another another prosecuting team not seeking the death penalty. This time, it's in the case of one Luigi Mangione. New York City, New York, City of Dreams. Anything in New York ain't always what it seems. Prosecutors said last Friday that they want to appeal a judge's ruling that bars them from seeking the death penalty against Luigi Mangione in the killing of United Healthcare CEO Brian Thompson. In a letter, Deputy U.S. Attorney Sean Buckley told Judge Margaret Garnett that the governors will not ask the Second U.S. Circuit Court of Appeals to reverse her decision, clearing the way for a trial beginning in September. His state trial, however, is not set to start. Is set to start in June. Garnett last month dismissed a federal murder charge, murder through the use of a firearm, that had enabled prosecutors to seek capital punishment, finding it was legally flawed. She wrote that she did so to foreclose the death penalty as an available punishment to be considered by the jury when it weighs whether to convict Mangione in the December 2024 killing in Manhattan. The judge, who's also a former federal prosecutor appointed to the bench by President Joe Biden, also threw out a gun charge but left in place stalking charges that carry a maximum punishment of life in prison. To seek the death penalty, prosecutors needed to show that Mangione killed Thompson with the passion, committing another crime of violence. Stalking does not fit that definition. Excuse me. Garnett wrote that in a letter. To seek the death penalty, prosecutors needed to show that Mangione killed Thompson while committing another crime of violence. Stalking doesn't fit that definition, Garnett wrote in a 39-page opinion, citing case law and legal precedents. The ruling disrupted the Trump administration's bid to see Mangione executed for what U.S. Attorney General Pam Bondi called a premeditated, cold blooded assassination that shocked America. It was the first capital case brought by the Justice Department in Donald Trump's second term. Okay. It's the first capital case brought by the Justice Department in President Donald Trump's second term. 27-year-old Mangione has pleaded not guilty in the federal and state cases. State charges also carry the possibility of life in prison. At a recent court hearing, he spoke out against the prospect of back to back trials, telling a judge, "It's the same trial twice. 1 + 1 is 2. Double jeopardy by any common sense definition." 50-year-old Thompson was killed on December 4, 2024, as he walked to a Midtown Manhattan hotel, for United Health Group's annual investor conference. Surveillance video showed a masked gunman shooting him from behind. Police say delay, deny, and depose were written on the ammunition, mimicking a phrase used to describe how insurers avoid paying claims. Mangione, a University of Pennsylvania graduate from a wealthy Maryland family, was arrested 5 days later after he was spotted eating breakfast at a McDonald's in Altoona, Pennsylvania, about 230 miles west of Manhattan. His lawyers have argued that authorities prejudiced his case by turning his arrest into a Marvel movie spectacle, including by having armed officers parade him up Manhattan Pier after he was flown to New York, and by publicly declaring their desire to see him executed even before he was formally indicted. Jury selection in Mangione's federal case is scheduled for September 8th, followed by opening statements and testimony on October 13th. His state trial is scheduled to begin June 8th, but the judge in that case, Gregory Caro, said she was having fun being let's see. Let me try it again. Yeah, I'm Sandman trying to hit me, and I'm fighting back. Jury selection of Mangione's federal case is scheduled for September 8th, followed by opening statements and testimony on October 13th. His state trial is scheduled to begin June 8th, but the judge in that case, Gregory Caro, said it could have been pushed back until September 8th if the federal prosecutors appealed the death penalty ruling. That's not happening. In her ruling, Garnett acknowledged that the decision may strike the average person, and indeed many lawyers and judges, as tortured and strange, and the result may seem contrary to our intuitions about criminal law. But she said it reflected her committed efforts to faithfully apply the dictates of the Supreme Court to the charges of this case. The law must be carried out. The law must be the court's only concern. This case has more drama than I've seen in some movies legally. Here's the overview. Let me take a drink real quick. Yeah, that'll do it. All right, here's the case overview. 27-year-old Luigi Mangione is accused of the December 4th, 2024 assassination-style killing of United Healthcare CEO Brian Thompson in Midtown Manhattan. Surveillance video captured a masked gunman shooting Thompson from behind as he walked to an investor conference. Mangione was arrested 5 days later at a McDonald's in Altoona. He faces both federal and state charges, with the state trial scheduled for June and a federal trial for September. Why was the death penalty removed? U.S. District Court Judge Margaret Garnett dismissed the federal murder through use of a firearm charge, which was the only count that made Mangione eligible for the death penalty. She ruled the charge was legally flawed because it relied on an underlying stalking offense, which does not qualify as a crime of violence under federal law. Without a qualifying predicate offense, the death penalty cannot be pursued. Garnett also dismissed a related gun charge, but left in place 2 counts of interstate stalking, which still carry a maximum sentence of life in prison. So until I went over this breakdown, I started to wonder, why did the prosecutors decide not to appeal that ruling? Federal prosecutors informed the court that they wouldn't seek interlocutory review of the judge's ruling, meaning they're not going to challenge the removal of the death penalty. The decision clears the way for the federal trial to begin in September. Former homicide prosecutor Jared Ferrantino described the move as strategic, not a retreat. Prosecutors face low odds of winning an appeal. Focus on securing a life without parole conviction is considered the more effective path. This was also the first capital case brought by a Justice Department in President Donald Trump's second term. Attorney General Pam Bondi had previously directed prosecutors to pursue the death penalty, calling the killing a cold-blooded assassination. The judge's ruling effectively shut down that pavilion. Oh. The judge's ruling effectively shut down that effort. So Mangione has pleaded not guilty in both the federal and state cases. He has publicly complained about back-to-back trials, calling it double jeopardy by any common sense definition, though legally the cases are separate. I get where, in a way, I can get where Mangione is going, but he needs to reread that section of the Constitution all over again. We will find out exactly where this case is going. When the state case gets underway, I will bring you my most beautiful sight yet on Mangione's case. So stay tuned to see what comes up next. As we're coming up on baseball season, this is not the news you wanted to hear. The next on our docket is former Major League pitcher Dan Serafini. He's entering my Justice Serve file after being sentenced for shooting his wife's parents. All right. As soon as my up on my end, I can go ahead and show you this 2-minute clip of the verdict, or either the verdict or the sentencing in Dan Serafini's case. All right, here we go. I'm gonna hide. I'm gonna mute, and the next thing you're gonna see is either being convicted or sentenced.
For the Twins, Cubs, Padres, Pirates, Reds, and Rockies. Daniel Serafini was a first-round pick Major League Baseball who pitched for the Twins, Cubs, Padres, Pirates, Reds, and Rockies over 7 seasons. He is now a convicted killer.
We, the jury, in the above entitled action, find the defendant, Daniel Joseph Serafini, guilty of murder in the first degree.
Homewood, Lake Tahoe, June 5th, 2021. A masked figure appears on the West Shore property. Prosecutors said 6 shots were fired inside the in-laws' home of Serafini by the masked and hooded man seen on surveillance footage. Robert Gary Spoor was killed. Wendy Wood survived the attack or died by suicide in March 2023, according to her family. Arrests followed of 2023. Samantha Scott, and Serafini's lover, later pleaded guilty to accessory, and she drove him, saw a handgun with a PVC silencer, and watched him discard items along I-80. Cell phone data played phone near the scene. Prosecutors said Serafini's motive was money and resentment of his wealthy in-laws, driven by post-career financial strain.
Daniel Joseph Serafini intentionally and personally discharged a firearm and proximately caused a great bodily injury to Wendy Wood to be, there's a finding of true.
One juror told KCRA the jury looked very closely at the cloaked figure seen in the surveillance footage, going frame by frame, focusing on body type, shoes, and the walk.
Murder by means of light weight, a finding of true.
By law, Serafini is expected to get life in prison without parole.
And I want a special thanks to Judge Ashley Wilcott of Court TV for the breakdown of that case. Hey, now the article goes on to say that Daniel Serafini was sentenced last Friday to life in prison without the possibility of parole in the 2021 shooting of his wife's parents during a burglary at their home by Lake Tahoe, according to authorities. 51-year-old Serafini was convicted in July 2025 of first-degree murder of his father-in-law, Gary Spoor, and attempted murder of his mother-in-law, Wendy Wood, and first-degree burglary. Spoor was killed and Wood survived, though she died a year after the shooting. Placer County District Attorney Morgan Geyers said last week in a statement that Spoor and Wood were loving grandparents and that Serafini's crimes greatly impacted family members and friends. The impact of this attack has extended far beyond the immediate victims, deeply affecting family members and the broader community, highlighting the lasting harm caused by deliberate violence, Geyers said. Serafini's attorney did not return requests for comment. During his sentencing hearing, Serafini addressed the court and maintained his innocence, according to My News 4. He said he was out partying with his wife the night of the shooting and described himself as a broken, imperfect man that makes mistakes. As Judge Ashley Wilcott mentioned in the video, he was drafted in '92 by the Minnesota Twins, and in a career spanning 11 years, the left-handed pitcher played for the Chicago Cubs, San Diego Padres, Pittsburgh Pirates, Cincinnati Reds, and the Colorado Rockies. Prosecutors said Serafini hated his wife's wealthy parents and was heard saying he was willing to pay $20,000 to have them killed, according to the Sacramento Bee. Prosecutors showed jurors transcripts of angry emails and text messages between Serafini and his in-laws. During the 6-week trial, Serafini's attorney, David Dratman, argued that there was no physical evidence linking his client to the crime scene. He told the jury although Serafini had a rocky relationship with his in-laws, he did not have motive to kill them. Following his conviction, Serafini filed multiple motions for a new trial, but those motions were denied. Serafini will serve his sentence at the California Department of Corrections and Rehabilitation, according to the Placer County District Attorney's Office. So we'll touch on this case one last time. Serafini is about 51, 52, depending on the source timing. He's sentenced to life without the possibility of parole for the shooting of his wife's parents at their Lake Tahoe area home. Gary Swore was killed by a gunshot wound to the head. Wendy Wood was shot twice in the head. She survived the attack, but died by suicide a year later. And again, anybody want to jump me about using sensitive language? I'm an outlaw by circumstance. I don't use sensitive language. Somebody gets shot, they get shot. What if the weapon happens to be a gun? Well, guess what? The word is gun, not pew pew. Not in my ear. Not the way I do things. If God forbid they die by suicide, I'm calling it as I read it. I'll call it as I see it. If you've got a problem, Facebook, X, YouTube, Instagram, TikTok, email, contact me. I will say the same thing on all those platforms. Back to the overview. The attack occurred during what prosecutors described as a planned, premeditated ambush. Serafini was convicted in 2025 of first-degree murder, attempted first-degree murder, and first-degree burglary. The jurors heard evidence of long-standing hostility toward his in-laws, angry emails and text message, and a witness who overheard Serafini offering $20,000 to have them killed. Here's the details. Prosecutors say Serafini broke into the home, waited for hours, and ambushed the couple when they returned home from a boating trip. Wood, despite being critically wounded, managed to escape the home and survived long enough to give investigators key information. The attack was described as execution style, deliberate, and motivated by financial disputes and deep resentment. As you heard, authorities also arrested Samantha Scott, described as Serafini's former nanny and alleged romantic partner. She was accused of driving Serafini to the home of the day of the shooting. She pled guilty to being an accessory. During sentencing, Serafini maintained his innocence, claiming he was out partying with his wife on the night of the shooting, calling himself a broken, imperfect man. During victim impact statements were delivered, and including the couple's daughter, who said he thought he had gotten away with murder. She asked the court to consider solitary confinement due to fear he might have someone kill her. The judge denied multiple motions for a new trial. Prosecutors had emphasized Serafini's premeditation, his hatred for his wife's wealthy parents, and the lasting trauma inflicted on the family and the community, the deliberate violence, and the extended harm that was caused. Again, as far as the background goes, he was drafted in '92 by the Minnesota Twins. Played 11 seasons in Major League Baseball with the Twins, Chicago Cubs, San Diego Padres, Pittsburgh Pirates, Cincinnati Reds, and Colorado Rockies. He also played internationally, Japan, Mexico, and Taiwan, and represented Italy in the World Baseball Classic. Now Serafini will spend the rest of his life behind bars. And that, ladies and gentlemen, is justice served. There's no two ways about it. I could have been watching this guy as a manager or coach in Major League Baseball. That won't be the case. Next on the docket. Come on. Okay. There's more than one way to get this link. Next on the docket, Lindsay Clancy is on trial, but she wants her murder trial for the deaths of her kids split in two parts. Uh-huh. All right, let's see. All right, I'm not going to run this entire 20 some odd minute video, but I will break this down for you. We're in Dedham, Massachusetts. Dedham, Massachusetts, we remember was famously known for Karen Reed's trial. Now we've got Lindsay Clancy about ready to stand trial. A Massachusetts mother accused of killing her 3 children has asked the judge to split her upcoming murder trial into 2 phases. Lindsay Clancy allegedly killed her children, ages 5, 3, and 8 months, by strangling them with exercise bands before cutting herself with a knife and jumping out of a second-story window. Clancy has never disputed her role in the crimes, but has argued in court documents that she was insane when the children were killed. At a motions hearing Monday, Kevin Reddington urged the judge to split Clancy's upcoming trial into 2 parts. Reddington, Clancy's attorney, argued that the Massachusetts Constitution supports bifurcating the trial, with the first stage focused on criminal liability and the second on criminal responsibility. The difference, Reddington said, is that the first trial will require the Commonwealth to prove that Clancy was the person who murdered the children. The second would be where prosecutors would prove that Clancy was mentally responsible for the crimes. Reddington said that combining the 2 stages would violate Clancy's Fifth Amendment protections against incriminating herself. Prosecutors pushed back at Reddington's request, saying that because Clancy is using an insanity defense, her Fifth Amendment rights were waived for interviews she's done with psychiatrists and other mental health professionals. Assistant DA Jennifer Sprague told Judge William Sullivan that the 2 phases of the trial would be nearly identical and require the same witnesses and evidence. Judge Sullivan said he would take the issue under advisement and release a ruling as soon as I can, quote unquote. Clancy is scheduled to sit for a psychiatric evaluation in April. The parties will return to court in May ahead of the trial, scheduled to start in July. Let's look at this case. Let's look over this case real quick. Lindsay Clancy is a 35-year-old Duxbury, Massachusetts mother charged with murdering her 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan, in January of 2023. Police say she strangled each child with exercise bands before attempting suicide by jumping from a second-story window, leaving her a paraplegic. She's pleaded not guilty and has been held at Tewksbury State Hospital since 2023. Her defense centers on postpartum psychosis, overmedication, and severe mental illness. The defense is requesting a 2-phase or bifurcated trial. Clancy's attorney, Kevin Reddington, is asking the court to split the trial into 2 distinct parts. The first phase is regards the criminal act. A jury determines whether Clancy committed the killings and to what degree. Phase 2, if found guilty, the jury then evaluates whether she was suffering from a mental disease or defect so severe that she could not appreciate the criminality of her actions or conform her behavior to the law. Reddington argues that combining both issues in one trial would violate her Fifth Amendment rights because presenting mental health evidence could force her to incriminate herself. The prosecutor's position is that now that they oppose the They opposed the idea because it would require the same witnesses and evidence, making bifurcation redundant. By raising an insanity defense, Clancy has already waived certain Fifth Amendment protections for psychiatric interviews, and the Massachusetts Constitution does not require the separation, and her attorney is requesting. Judge William Sullivan, as I said, has taken the matter under advisement and has not yet ruled. Keep it here for whenever that ruling does come down. In the meantime, recent hearings have focused on scheduling and logistics for Clancy's in-person appearances, which her attorney prefers to help her acclimate emotionally. Motions regarding the recording of her psychiatric interview, a defense request for early access to the jury list, arguing that the current process is inadequate for ensuring a fair trial. Upcoming psychiatric evaluations are ordered by the court. Currently, her trial is scheduled to begin on July 20th. Clancy and her husband have filed separate civil lawsuits against her medical providers, alleging failures in treating her postpartum depression and mental health crisis. Her defense team maintains that postpartum psychosis combined with overmedication drove the tragedy. Legal analysts note that this case sits squarely with the most challenging category of insanity defense trials, given the emotional weight and ages of the victims. And that truly is a tough case to navigate through, because not only does the defense have to go far beyond the scope of reasonable doubt to prove their client's innocence. And if that client happens to be found guilty, they got to wade through those waters again to say, okay, my client is guilty of this crime, but he or she was not in the proper headspace to um appreciate, that's the word that they're using, what he or she has done. So again, like I said, whenever the judge makes that ruling, you'll have it here first. Next up, Stacy Wandra, a man accused of murdering missing 5-year-old Michael Monkey Vaughn, makes his first appearance in court. It's nearly 5 years after 5-year-old Michael Monkey Vaughn disappeared at his Fruitland home in July 2021. The man charged with kidnapping and killing him, Stacy Wandra, is back in a Fayette County courtroom on Tuesday as preliminary hearings get underway. Stacy Wandra is the only person charged in the death of Michael Vaughn, although Fruitland police publicly named 4 people as suspects in the case in 2022, including Stacy's then wife, Sarah. Sarah Wandra was arrested in 2022 and charged with failing to report Michael's death, but she was later released when prosecutors dropped those charges. Michael's body was never found during an extensive search of the Wandra's home and backyard. Stacy appeared in court on Tuesday in civilian clothes and shackles. The prosecution began their arguments by laying out the probable cause they say would prove he committed murder, and then destroyed evidence to obstruct the investigation. The state argued that Stacy confessed to law enforcement, telling police Michael was abducted and taken to his Fruitland home in July 2021 before being put in a duffel bag and taken to another location in Kuna. Prosecutors say Stacy saw Michael buried in his backyard, but the boy's body was never located. At the time in 2022, law enforcement shared their theory that Michael was buried at the Wandra home, then later moved to a new location. The body has never been recovered. There you go. As you look at that photo of Michael Monkey Vaughn on the left side of your screen, the article continues with the defense offering brief opening remarks stating, "Our client confesses to nothing." The state called Michael's father, Tyler Vaughn, to the stand. Tyler Vaughn is the person July 27, 2020, 911. Tyler told prosecutors at the time of Michael's disappearance he was not familiar with the Wanderers or anyone in their home, which is about a half a mile away from the Vaughn's family home in Fruitland. Tyler laid out what was happening at the family's home the day Michael went missing. His wife, Brandy, was at work. He had the day off and was home with the family's children. Tyler recalls spending time playing monster trucks with Michael that day. He testified that he saw Michael playing in the family living room when he went to wake up the then 2-year-old around 6:15 p.m. She could be hard to wake up, he explained, so it took a few minutes. He then changed a diaper, ordered pizza for dinner, then realized Michael wasn't in the home around 7 p.m. He looked all over the house and called Brandy, who thought maybe Michael was hiding. After he was unable to locate Michael quickly, he says he called police around 7:20 p.m. The defense teams questioned Tyler's use of marijuana at the time of Michael's disappearance. Tyler said he usually smoked a couple joints a day outside their home. Tyler testified that he smoked a joint between the time he woke up their sleeping toddler and when he noticed Michael was missing. Tyler told the defense that once police arrived at their Fruitland home that night, he and Brandy stayed in close proximity to the home, searching for Michael in the neighborhood. As Michael's mother, Brandy began her testimony. Members in the courtroom gallery were visibly emotional, wiping tears. Brandy recalled that the July day Michael went missing. She was working at Albertsons when she received a phone call from her husband, Tyler, who could not find Michael. She told him to look under their bed in his favorite hiding spot, but Michael wasn't there. Brandy testified that she immediately left work and called her older daughter on her way home, instructing her to get home right away to help look for Michael. Brandy appeared visibly emotional when prosecutors asked her if she ever located Michael or saw him again. No, Vaughn stated sadly while grabbing a tissue. Let me take this link because that's going to be my update piece for this one. Brandy told prosecutors she gave police several items to assist in the investigation that may include Michael's scent or DNA, including a shoe, his pillow, his favorite blanket, and a stuffed animal. The prosecution called Dustin Witt to the stand, who at the time of Michael Vaughn's disappearance worked in law enforcement in California. Witt has experience with SWAT and canine investigations and testified that the FBI requested his assistance in the Michael Vaughn case. Witt and his canine were flown to Fruitland in August 2021 in the days following Michael's disappearance. Witt testified his bloodhound is trained to follow a scent. Police used items collected from the family to allow the dog to smell Michael's scent. Will testified his certified bloodhound led officers to a location near Red Wing Street, which is about a half a mile from the Vaughn's family home. Witt says the canine was on trail and cut across a front yard to lead detectives to a house on the corner of Meadowlark and Red Wing. All right. Witt testified This canine showed interest in the corner of the property near the fence to the backyard. He led the dog away from the home and took her off the leash. When he says the dog turned back around and went directly back to the fence line. Past that home, the dog did not have trailing behavior. On another search, the canine also appeared to show good trailing behavior along 8th Street at a bluff nearby, down a dirt road, and led officers to an area of thick vegetation where Witt says he stopped the dog from entering the thorny bush. And now the update on this case. We got some grim details about the abduction of 5-year-old Michael Vaughn that were revealed in court as Stacy Wandra's police interview was played during his preliminary hearing. As you know, Stacy Wandra's multiple charges, including murder and kidnapping in Michael's death. Vaughn disappeared in July 2021. Stacy Wandra's wife, Sarah, was responsible for the child's abduction and killing. At a preliminary hearing spanning multiple days, prosecutors have laid out evidence, including videos of Stacy Wandra speaking to police in November 2022 while in custody. The recording shows the defendant walking detectives through the day of Michael's abduction. Stacy Wandra told the detectives that he was not involved in any way with taking Michael, but that his wife took him after seeing him outside. It sickens me, he told detectives, denying he had any part in the planning. When Sarah Wandra initially asked what to do with the child, her husband said, "I suggested that we call the authorities." Rather than call police, Stacy Wandra said he then went to the couple's bedroom, leaving Sarah Wandra with their 2 roommates and the child. Stacy Wandra said the adults then duct taped Michael. "I didn't sit there and watch them wrap him up," he said. "But in the bedroom, I could still hear the tape being unrolled and the child screaming, 'I want my mom. I want my mommy.'" Oh my God. Excuse me a second, guys. Whew, wow. I want my mom. I want my mommy. Stacy Wandra said that when he asked his wife why he took the child, she blamed him for not earning money and said that their roommate would get a hold of this person to see if he would buy a kid. What? The last time Stacy Wandra said he saw Michael, the child had been placed in a duffel bag between layers of clothing. At one point during the police interview, Stacy Wandra began to vomit, citing the stress of the situation and the story. Michael's body has never been found. Ladies and gentlemen, you think if you think there are 3 tough cases in court that is tough to gain an acquittal for, and I've seen all 3. One is self-defense. 2 is not guilty by reason of insanity. And this would be number 3, a no-body murder case. I'll go ahead and get down to the core facts. It's been nearly 5 years since Michael Monkey Vaughn vanished from outside his Fruitland, Idaho home on July 2021, excuse me. The man accused of kidnapping and killing him, Stacy Wandra, has appeared in a Payette County courtroom for preliminary hearings. Wandra is the only person currently charged with Michael's murder, though 4 individuals were publicly named as suspects in 2022. Michael's body has never been found despite extensive excavation of the Wandra property and surrounding homes. Let me back up real quick because I jumped way too far ahead of myself here. All right. Michael's body has never been found despite extensive excavation of the Wandra property and surrounding areas. Wandra is facing multiple felony charges, including first-degree murder, kidnapping, destruction of evidence, and persistent violator enhancement. These charges stem from the prosecutor's belief that Michael was abducted, taken to the Wandra home, killed, and later moved to another location. Key evidence that has been presented in court included testimony from cadaver dog handlers and investigators. First, cadaver dog handler Julie Gibson testified that her certified cadaver dog, Yodi, alerted near an irrigation box in the Wandra backyard during the 2022 search. She emphasized that her dog does not false alert. She also explained that the scent could travel through underground pipes, potentially explaining why the alert occurred in that certain specific location. That's according to KIVI TV. The backyard was dug deeper than she was tall, except a narrow perimeter, as investigators searched for Michael's remains. Another canine handler, Dustin Witt, testified that his canine showed interest along the fence line and garage area of the Wandra property. The alleged keyword. Prosecutors say Wandra told investigators that Michael was taken to his home, placed in a duffel bag, and buried. V was later moved. The defense disputes this, saying our client confesses to nothing. Michael's father, Tyler Vaughn, testified about the day. Ah, ah. I'm trying to catch this thing back because I'm going a little too far with it. Uh-huh. Okay, dog expert says, okay. All right. All right. The testimony from Michael's family. Michael's father, Tyler, testified about the day his son disappeared. He was home with the children while his wife worked. He last saw Michael playing in the living room around 6:15 p.m. After tending to his younger child, he realized Michael was gone around 7 p.m. and called 911. Michael's mother, Brandy, attended the hearing and said seeing Wandra in court triggered panic, but also relief that the case is finally moving forward. Wandra was extradited from Arizona to Idaho in November 2025. The preliminary hearing began March 3rd, 2026, and is expected to last several days. The judge confirmed both sides are ready to proceed, though discovery is still ongoing. All right. We're now going to take you to a case that's underway right now. This is the Reluctant Victim Assault Trial, Massachusetts versus Lucy Medina. It's also being called the Parasitic Marriage Assault Trial. All right, here we go. I guess this is breaking news, ladies and gentlemen. I guess this trial didn't last long at all. I am going to hide myself and mute myself as we're finding out now that as I'm looking at this is now a verdict watch. So I'm gonna take you right into that, and we are going to get the verdict right now.
Jurors and defendant remain standing. All others be seated.
Mr. Forbes, your jury agreed upon a verdict.
Yes.
May the court please. Mr. Foreperson, what say you to indictment 2021 CR 239, charging the defendant, Lucy Medina, with assault and battery with a dangerous weapon causing serious bodily injury? Is the defendant guilty or not guilty?
Not guilty.
Ladies and gentlemen of the jury, hearken to your verdict as the court has recorded it. You, upon your oaths, do say that the defendant, Lucy Medina, is not guilty on indictment 21 CR 239, charging her with assault and battery by a dangerous weapon causing serious bodily injury. So say you, Mr. Foreperson.
Yes.
So say you, all members of the jury.
Yes.
Your Honor, may the verdict be recorded.
It may be.
Thank you.
Okay, so Judge, you can be seated. All right. I won't keep you long, but I do want to thank you on behalf of the Commonwealth and the defendants, defense counsel. Appreciate your time and attention in this trial. I'd ask you if you could, and I know we've taken a lot of your time, but I would like to come back a few moments and speak to you and thank you personally, answer any questions you may have about the process. I don't want to know, and I'm not going to ask you about your decision making, but again, I would just like to extend my thanks in person. Able to say I fully appreciate that. I'll be back in about 5 minutes. But with that, your service is complete. We thank you for your service and have a good day.
All right. Jury on that. You may be seated.
Your Honor, may I discharge the defendant? Please stand. Ms. Medina, 1 CR 239, charging causing serious bodily injury. The jury, having returned a verdict of not guilty, this court orders that you be discharged of this indictment and this indictment only, and go thereof without delay. You may be statute. The records regarding the charge for which you've been found will be sealed by the Commissioner of Probation and by the court unless you Commissioner of Probation within 10 days in writing that you do not want those records sealed. That they not be sealed, you may use a form available on the mass.gov website. I cannot the form here in court. You must submit it to the Commissioner of Probation at the IDAHO. You understand, ma'am? Yes. Thank you. Thank you.
Thank you.
Okay, so I want to thank counsel in cases well to both sides. I appreciate, I want to comment on how professional you were and courteous to each other, maintaining your positions, representing the Commonwealth and the defendant, but you worked well together, and I get that. And Ms. Medina, I would best of luck for the future. And with that, unless we have anything else, we're adjourned.
Thank you, Your Honor. Thank you so much.
guilty on charges of aggravated assault and battery with a dangerous weapon and assault and battery on a family or household member after using a knife to cut the throat of her husband, Luis Medina. Luis survived the attack, but Lucy's defense, her husband has, quote, never given his account of what occurred when he was stabbed on July 17th of 2020. Luis Medina did not appear on the witness stand, but his attorney, Murat Erkan, was called to testify. Included in his testimony was a letter sent to the court from Luis that says Mr. Medina firmly believes that if the defendant was the source of his injuries, she acted in self-defense. He is adamant that the defendant that Luis confessed to him that he beat his wife. Lucy's co-workers also took the stand during her trial, describing her coming to work with bruises that she would blame on falls. Frequently, after the bruises appeared, flowers would be sent to her at work. Co-workers said Lucy never seemed happy about the flowers. So, Lucy Medina, again, she was charged with assault and battery with a dangerous weapon and assault and battery on a family or household member. She was found not guilty on all charges. She was argued as her defense argued that she was the true victim of long-term domestic abuse and acted in self-defense. The case was framed that way because of the alleged victim, Luis Medina, her husband, is expected to refuse to testify. He was on the prosecution's list. The defense says he would invoke both spousal privilege and the Fifth Amendment. A letter from Luis states that he believes Lucy, acted in self-defense and committed no crime. This creates a rare situation where the prosecution's named victim does not support the state's case, in which the prosecutions believe that Lucy made the choice to escalate the argument by retrieving a knife, stabbed Luis in the neck, nearly killing him, could have walked away instead of using deadly force, should not be allowed to introduce remote, vague hearsay statements about prior abuse. Their strategy focused on intent, opportunity to retreat, and reasonableness of force. Lucy Medina's attorney argued that Lucy was a battered woman suffering from PTSD and years of abuse. The relationship was parasitic and toxic, according to a forensic psychologist. There were photos that shown Lucy was beaten and unable to walk away. She acted to survive, not to attack. The defense planned to call an expert on battered woman syndrome to explain her mental state. The 911 call was played in court with Lucy's emotional distress audible. A neighbor testified, Maria Sanchez, who lived above the Medinas. There is medical evidence showing the severity of Luis's neck wound and prior domestic violence context, which the defense argues is essential to understanding Lucy's actions. The key legal questions for the jury that led to this verdict: who was the first aggressor, Luis or Lucy? Was Lucy's use of a knife reasonable under the circumstance? Does the history of alleged abuse justify her perception of danger? And how should this jury interpret a victim who refuses to testify and claims the defendant acted in self-defense? Those questions made the case unusually complex for a domestic violence prosecution, but apparently this jury made it seem so easy to come back with a not guilty verdict for Lucy Medina. So, even with a not guilty verdict, this sounds to me like another case of justice served. And speaking of justice served, we're gonna go from let's see, where was this last case? Oh, that's right. This was in Massachusetts, right? We are gonna head down I-95. We're going to head down I-95 for the next case on the docket. The verdict in the Gave My Son a Gun trial. And once again, I am going to take myself out of the shot. I'm going to mute. And the only thing you're going to hear will be that of his verdict and the judge in the case. If I can get this thing to correct. Okay, there we go. Now, all right. I'll be back with my comments after we hear this verdict. And as you can see on the screen now, the verdict is in.
Breaking news, we have a verdict in the case against Colin Greja. This is the case of a father accused of basically aiding his son in a high school shooting. So people ended up in 2024 after Cold Gray showed up at Appalachia High School with a gun that he received from his father, who gave it to his son as a the Christmas prior. And prosecutors say he should have known better. The jury has, for an hour and 49 minutes, it's an incredibly short time to deliberate. Let's go to Georgia, to the courtroom, see what the jury has decided.
Madam Foreperson, I understand the jury has reached a verdict. Is that true?
Yes.
So was the verdict unanimous?
Yes.
And have you signed, dated it, and filled the verdict where applicable?
Yes.
All right, would you hand it to the bailiff? Thank you, sir. And then counsel, if y'all want to approach to inspect it. Any objections to the form or legality of the verdict?
Not from Second Honor.
No, Your Honor. Ms. Jones, if you will publish the verdict.
In the Superior Court of Barrow County, State of Georgia versus Colin Gray, case number 24-CR-593-P. Jury verdict. Count 1, murder in the second degree. We, the jury, find the defendant guilty. Count 2, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 3, murder in the second degree. We, the jury, find the defendant guilty. Count 4, cruelty to children in the second degree. We, the jury, find the defendant guilty. Count 5, involuntary manslaughter. We, the jury, find the defendant guilty. Count 6, reckless conduct. We, the jury, find the defendant guilty. Count 7, involuntary manslaughter, unlawful act. We, the jury, defendant guilty. Count 8, reckless conduct. We, the jury, guilty. Count 10, children in the second degree. we, the jury, find the defendant guilty. Count 11, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 12, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 13, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 14, cruelty to second degree, we, the jury, find the defendant guilty. Count 15, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 16, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 17, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 18, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 19, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 20, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 22, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 23, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 24, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 25, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count 26, cruelty to children in the second degree, we, the jury, find the defendant guilty. Count reckless conduct, we, the jury, find the defendant guilty. Count 28, reckless, we, the jury, find the defendant guilty. Count 29, reckless conduct, we, the jury, find the defendant guilty. This third day of March 2026, signed for person.
Thank you, Mr. Jones. Counsel, the leases of the jury or anything with the jury?
Yes, Judge, we'd ask Mark to poll the jury.
All right. So, ladies and gentlemen, the defense has asked that I poll the jury. What I am going to do is call out the juror number. I'll ask you to stand. I'm going to ask, was it your verdict in the jury room? Was it freely and voluntarily entered by you, and is it still your verdict? Juror number 2, stand. All right. Ma'am, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your? Thank you. Juror 49. Ma'am, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 50. Sir, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 52. Was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you? Is it still your verdict?
Yes.
Thank you. Juror 63. 63. Sir, was this your verdict in the jury room? Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 71. Ma'am, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict? Thank you. Juror 77. Sir, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 82. Sir, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict? Thank you. Juror 97. And was this your verdict in the jury room?
Yes.
Was it voluntarily made by you?
Yes.
Is this still your verdict?
Yes.
Thank you. Juror 99. Sir, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 102. Sir, was this your jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is it still your verdict?
Yes.
Thank you. Juror 103. Ma'am, was this your verdict in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Do your verdict.
Yes.
Thank you. Any reason why the jury should not be released?
Not for state, Your Honor. No, Your Honor.
All right. Ladies and gentlemen, if y'all will, go ahead and just go back to the jury room. I'll come back and address you.
Sir.
You can put the alternates back in the seat.
Yes, sir.
Regular jury. All right. And Mr. Gray, custody. Obviously, we're not doing sentencing today. This will be deferred. Don't take it yet. Maybe I touched it. So sentencing will be deferred. I probably meet with counsel in chambers and the sentencing if that works. And we'll go from there. And then the sheriff's office will order. Else we need to address today.
Before you talk, would you mind if me and Clifford just quickly?
Yeah.
All right, there it is. Colin Gray, guilty on all charges. He will likely spend the rest of his life behind bars for giving his son that high-powered rifle, which was used in the high school shooting, which killed 2 students and faculty members and injured 9 other students. Some of
Let me shout out and thank Court TV's Ted Rollins for coverage on that verdict. Ladies and gentlemen, you heard it here. Colin Gray will likely spend the rest of his life behind bars because he was found guilty on all counts related to giving his son a high-powered rifle, and he used that rifle to kill killed 4 and wounding so many others at a Georgia high school. As you heard, he was found guilty on 29 counts, including the following: second-degree murder for deaths of 2 students, involuntary manslaughter for the deaths of 2 teachers, 18 counts of cruelty to children, and 5 counts of reckless conduct. Prosecutors argued that Colin Gray bought his son an AR-15 style rifle as a Christmas gift, despite clear warnings about the boy's mental instability. He ignored red flags, including a prior threat by Colt to shoot up a school, a shrine in Colt's bedroom dedicated to mass shooters, including Parkland gunman Nicholas Cruz, and had violent tendencies and a documented decline in mental health. He was allowed unrestricted access to the weapon and ammunition. Prosecutors said Colin Gray was the one person who could have prevented this tragedy. Apparently, this jury agreed. As you saw at the very end, he was handcuffed in court immediately after the verdict. Sentencing will occur at a later date, and he faces decades to life in prison. Colt Gray, who has yet to stand trial yet, was 14 years old at the time of the shooting. He faces 55 felony counts, including murder. He allegedly boarded the school bus with a rifle hidden in a book bag, wrapped in poster board. I don't know how he was able to pull that off. He carefully planned the attack, leaving behind a notebook with diagrams and instructions. He has pleaded not guilty, and he is still awaiting his trial. Why is this case legally significant? This conviction pushes the national conversation forward on parental accountability in these school shootings. It follows the precedent set by the Crumbly case in Michigan, where both parents were convicted after their son's 2021 school shooting. Now, let me remind you, James and Jennifer Crumbly were found guilty after Ethan was found guilty and sentenced to life in prison for the school shooting in Michigan. James and Jennifer were both sentenced to 10 years apiece. Prosecutors emphasize that parents who enable access to weapons despite clear warning signs may now face severe criminal consequences. So, parents, in the immortal words of Aretha Franklin, think about giving your child a gun. Think about giving that child unrestricted access to said gun, because if the next school shooting that happens may not just be on your child, it could be on you too. You heard it here first, right here at Bethea'S Byte Reloaded. But for now, as far as Colin Gray goes, until sentencing, justice is served. And I believe I am on my final story on this not so perfect 10 docket. Yes, I am. And I have a great deal to say about this one. Hang on tight, guys. A man allegedly tried to express himself to his mother before beating her to death when she didn't listen. Check this out, guys. This is 38-year-old Haywood Jenkins. He's charged with first-degree intentional homicide in connection with the death of his mother, Cheryl Jenkins. Here's all you need to know. 38-year-old Haywood Jenkins is charged with first-degree intentional homicide in connection with the death of his 66-year-old mother, Cheryl Jenkins. He said he got into an argument with his mother over silver coins, money, and her not listening when he was trying to express himself. That's according to a criminal complaint made by People magazine. The Milwaukee County Examiner's Office concluded that Cheryl died from blunt force injuries. Let's go to Wisconsin for this last story. A Wisconsin man is accused of beating his mother to death with a baseball bat. 38-year-old Haywood Jenkins is charged with first-degree intentional homicide in the alleged killing of his 66-year-old mother, Cheryl Jenkins, according to a criminal complaint obtained by People magazine. Officers were called to the 1700 block of South 44th Street in Milwaukee just after 8 a.m. on February 24th, after Cheryl's fiance told dispatch that Jenkins hit her on the head with a bat and then fled the scene. At the residence, officers found Cheryl lying face down on her stomach with a wooden baseball bat on top of her in a guest room, according to the complaint. There also appeared to be blood on the barrel of the bat, according to police. Emergency personnel administered CPR, but she was pronounced dead at the scene. The room where Cheryl was found appeared to be cluttered and had a broken metal bed frame. Cheryl's fiance indicated that this was not how the bedroom appeared the day prior, according to the complaint. Officers also discovered, per the complaint, what appeared to be blood splattered on the back side of the bedroom door and on the lower corner part of the east wall. The Milwaukee County Medical Examiner's Office ruled that Cheryl died from blunt force injuries. Cheryl's fiance claimed Jenkins arrived at their home between 9 and 10 p.m. on February 23rd, the evening before the alleged homicide. He told police that Cheryl got Jenkins something to get him to sleep in the guest room. The fiance told police that he woke up around 4 a.m. to a noise, though he thought the noise was coming from the upstairs neighbors and went back to bed. He says Cheryl was not in bed at that time and he thought she was in the guest room with her son, according to the complaint. That morning, around 7:30 a.m., he found Cheryl lying on the floor of the guest room and called 911. Fled the home. He was later taken into custody at a casino just after 12. In a Mirandized statement to police, Jenkins allegedly said he got into an argument with his mother over silver coins, money, and her not listening when he was trying to express himself, according to the complaint. The defendant stated that his mom blew off his concerns and kept. The defendant stated that his mother had scissors up to him and was looking at him like she was going to do something, the complaint states. According to police, Jenkins allegedly said that he felt that he and his mom were getting nowhere and he had exhausted every situation that he could, and he got very angry with the situation and flipped out. He told police he got the baseball bat and that he never wanted to hit her with it. The defendant stated that he struck his mother in the head with the bat multiple times while she was sitting in a chair, the complaint states. The defendant stated that he was wrong for murdering his mother, per the complaint. A preliminary hearing is scheduled for Tuesday, March 10th. Jenkins' attorney could not be reached for comment. Money, silver coins, and not being able to express himself. Come on. All right. You already heard the case overview. According to the complaint, as we've mentioned, Jenkins told investigators was trying to express himself to his mother about personal frustrations. When she didn't respond the way he wanted, he allegedly became enraged. Prosecutors say he then beat her with a baseball bat, striking her multiple times in the head and upper body. The attack was described as prolonged, violent, and Cheryl dying. The police discovered this crime saying a family member requested a welfare check after being unable. Officers arrived and found her unresponsive with severe injuries consistent with blunt force trauma. Jenkins was still at the residence and taken into custody without incident. Jenkins allegedly admitted he attacked his mother after feeling unheard and overwhelmed. He reportedly described the confrontation as emotionally charged and said he lost control. The complaint does not indicate that he attempted to flee or conceal the crime. Jenkins is charged with intentional homicide, the most serious homicide charge in Wisconsin. If convicted, he faces life in prison. Being held in custody pending further court proceedings. Let me go ahead and speak my piece. Let me go ahead and speak my piece on this. Let me stop sharing this. So you're into this argument or discussion with your parent over, I don't know. Let's take the situation that we're dealing with here. Money, silver coins, and whatever else is going on. Fine. You're a grown man. You should be able to talk to your mother about that with no issues. You feeling like you're not being heard. It's only because mom's got your best interest at heart, which means you be quiet, let her speak, you listen. You got two of these for a reason. You have one of these for a reason. You shut this one, you open these two up. Then, when she's finished speaking to you, then you can express yourself. And if things still don't go the way you want it to go, it's okay. That's gonna happen. That's moms for you. But nowhere do you have the right to pick up a baseball bat and bludgeon your mother with it. I don't care how long the talk goes. When it comes to your mother, you only get one in this life. Be thankful you have her. Haywood Jenkins, as far as I'm concerned, and I just turned 50. My mom's been gone since 2000. I would never in my life think to pick up a baseball bat and bludgeon her over the head when she's trying to talk sense into me. To this very day, I wish she was alive so she can talk some sense into me. Sure, I make mistakes. I made a lot of them. Probably will make more before my time is up. But the one mistake I won't make is taking my mom's life if she was still around. And that's all I got to say about that. I am going to wrap this up and say thank you guys for joining me here at Bethea'S Byte Reloaded, this special Friday afternoon, early Friday evening edition of the main event. And I am coming back tomorrow with a little short session for Saturday night's main event. So let's bring it back here tomorrow night, all right? Again, thank you all so much for joining me. If you liked everything you saw and heard today, please be sure to like, share, subscribe, drop me a comment, and show your support for Bethea'S Byte Reloaded. This is the free way to support this channel. I appreciate every last bit of it. And you can also contribute financially too. This is only out to keep this thing running. If you want to, you can go through PayPal me /EKB316, or by Cash App $EKB316. And as a good friend of mine would say, nothing is obligated, but it's always appreciated. Also, you can always get in contact with your boy all over social media, as I said before, especially when I call things out as I see it, as I hear it, and as I read it. I'm not internet friendly. I'm an outlaw. Get it? If you don't like that part about me, Hit me up on Facebook and say so. I'm at Bethea'S Byte Reloaded. Hit me up on X and say so. I'm at EKB316, all caps. Hit me up here on YouTube at Bethea'S Byte Reloaded. Say it on Instagram at EKB316, lowercase. Say it on TikTok. I dare you. I'm at King of Hearts 316 2021. Or please, I am begging you to drop me an email. I'm giving you my email address flat out. It's King of Hearts 316 _09 at outlook.com. I will respond. Just keep it all clean. I do respond to you. Guaranteed. All right. So in other words, that's gonna do it for me. I mean, you are inside the drama-free true crime destination, where I bring you true crime news without all the drama, where your opinions matter, where lively debates are encouraged, your voice is heard, and above all else, justice is served. And I do it, and I do this only one way and one way only, with no gimmicks, no drama, and no BS. All right, guys, I'm gonna get up out of here. And again, I thank you all so much for joining me. I appreciate you. I love you. And we'll do this. Let's do this again tomorrow night, or tomorrow afternoon, however soon I can get to you, ladies and gentlemen. This is the main event, and of course, this is Bethea'S Byte, and it's reloaded. I'll see you next time. Thank you so much for joining me here at the drama-free true crime destination. Please be sure to follow Bethea'S Byte Reloaded all over social media and support the channel through PayPal and Cash App. You can get your true crime news right here with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.